Now to tonight's guest. Tonight we are joined by a man who is no stranger to controversy. After graduating from Yale and Bolt Hall, Edwin Meese worked as district attorney in California. From there he began his political relationship with then-Governor Ronald Reagan, serving as his chief assistant. After some time as a business executive, a private lawyer, and a faculty member at the University of San Diego, Mr. Meese rejoined President Reagan, then as his domestic affairs advisor in the White House. In 1985, Mr. Meese became the 75th Attorney General of the United States. Under Mr. Meese, the Justice Department began a far-reaching campaign to fight America's drug war. Mr. Meese is now a distinguished fellow at the Heritage Foundation and at the Hoover Institute. Please welcome Mr. Edwin Meese.
Thank you very much. It's a pleasure to be here at the Harvard Law Forum, and good to be back in the legal educational community where I've spent a good portion of my own professional career either on a part-time or full-time basis. I work today, however, in a public policy research institution, a think tank, if you will, in which the lawyers are a distinct minority. Indeed, at the Heritage Foundation, we have primarily economists that I work with on a daily basis. And of course, the 4 or 5 of us who are lawyers have an ongoing rivalry with the economists. We have the usual jokes. They like to tell the joke that I'm sure most of you have heard about lawyers asking the question, why is it that the leading medical scientists now use lawyers instead of laboratory rats for the more dangerous experiments? The answer, of course, being that with the lawyers, the doctors don't get that feeling of affection they sometimes get for the rats. We, of course, reply in kind that the definition of an economist is an individual who didn't have the personality to be an accountant. I've been asked tonight to speak on the topic freedom, free speech, and the courts. And I will do that. It's an important subject. It's actually occupied the attention of the Supreme Court and the federal judiciary over most of the 203 years of our republic. And then after my initial remarks, which I'll try to keep reasonably short, I will open it up to questions, and I'd be glad to answer your questions on this topic or on any other topic where you think I might be able to respond to you so that we can turn a monologue into a dialogue, and I can respond to what might be most on your mind. Archibald Cox, who is probably well known to many of you, at least by reputation, wrote an article on freedom of expression that appeared in the November 1980 issue of the Harvard Law Review. And in that, he spoke about freedom of expression and talked about it up until that time, first quoting the First Amendment to the Constitution, which I'm sure you know, but I'll mention it just because it bears on what I'm going to say this evening. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, and then particularly, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble or to petition the government for a redress of grievances. And in his article, he said the numerical position of the First Amendment is symbolic because freedom of conscience and expression enjoys primacy in our scale of rights. Now, an interesting side note is that when the amendments were actually presented to the Congress, our first Congress in 1789, freedom of speech and expression and religion was not the first one presented. As a matter of fact, one of the first 2 that was presented had to do with congressmen and their pay, but that one didn't get passed, but it does give you an idea as to what Congress had in mind as to primacy at the time. But then he goes on to say, the juxtaposition of the key phrases in the First Amendment reveals much of the philosophy underpinning those guarantees of particular fundamental rights. The framers put freedom of conscience first and then moved on to freedom of speech and the press. They knew that a man burdened with an idea has a need, even feels a moral duty to express it. Well, I think this gives some idea of the importance that they attached in the early days to freedom of speech, because it was more than just the idea of people being able to express those ideas that they held, that they felt were so important, but rather it was the very essence of the ability of people to express their ideas, to gain adherence, and ultimately to obtain like-minded folks to join them in trying to influence the political and policy apparatus of those days. Archibald Cox goes on to quote Alexander Meiklejohn, whom he describes as perhaps the foremost American philosopher of freedom of expression, who said that the guarantees of freedom of speech and of the press hold an absolute preferred position because they are measures adopted by the people as the ultimate rulers in order to retain control over government, that is, the people's legislative and executive agents. And so it's in this sense that we look at freedom of speech and freedom of the press as key elements that have an importance beyond simply the fact that they were among the first 10 amendments to the Constitution and an important part of the Bill of Rights. Now, at the outset of my remarks tonight, I'd like to suggest three propositions to you. First of all, that the legal and the constitutional protections of freedom of speech are as great today, and in some ways perhaps even more extensive than they were in the days of the founders. And incidentally, I've talked about and will be talking a lot about freedom of speech, and when I talk about that, in a sense, I'm also including freedom of the press, because freedom of the press is really a corollary, being the printed means of expressing ideas, just as speech is the verbal or spoken means of expressing those same ideas. But it's the idea of being able to express a thought or a concept that is important, whether it be by the spoken or by the written word. The second proposition I'd like to suggest to you is that the kinds of issues that come to the courts, including the Supreme Court, under the banner of free speech, are perhaps today more varied and more complex than ever before. And in one case, at least in one case, the parties taking different sides are very peculiar in view of what you might expect them traditionally to take. And third, I'm going to suggest that the greatest threat to freedom of expression in our society today comes from outside the government, legal, judicial context. Well, let's talk first about the position of the legal and constitutional protections of free speech today. Now, the courts have held that freedom of speech in the press, despite their importance, and as Archibald Cox said, their primacy, are not absolute. And of course, that's true of most rights. And as you found out, I'm sure, in your studies, most legal maxims, and that is there are always exceptions. And so in the case of defamatory publications or defamatory statements, all the way back to common law as it was brought over to this country, this was an exception to the concept of free speech, recognized as such by the framers of the Constitution and those who drafted the Bill of Rights and the Congress that adopted them. National security, under certain circumstances, can be a factor in limiting free speech, particularly as it pertains, for example, to national security classified information and secrets. The integrity of judicial proceedings can be compromised by certain things, particularly, and this has been applied primarily to lawyers in a judicial proceeding, where the judge places what is known familiarly as the gag rule upon them, and the courts have generally upheld this as a legitimate regulation of free speech in their case because of their overriding responsibility as officers of the court and the overriding need to maintain the integrity of the judicial process. Obscenity has historically, again back to common law, been accepted as something that is outside the protection of the First Amendment. And then there are needs pertaining to public order and safety, in which the needs of, or the requirements of the First Amendment also have to, in some cases, be limited. We've all heard the familiar example that a person cannot cry fire in a crowded theater when there is no fire. There are other limitations that have been upheld over the years, such as picketing, demonstrations, and parades, and I'll talk a little bit about that in a moment as to the way in which those have been limited legitimately, even despite the provisions of the First Amendment. Now, most of the things that I've mentioned as limitations or possible limitations on the First Amendment require some balancing of competing interests, including even constitutionally protected interests in order to arrive at something that can accommodate the needs of society without compromising the basic ability of people to utilize the First Amendment to protect their basic and fundamental rights in order to use speech as a political tool. And usually this balancing has two categories. First, the regulation of content, which is rarely permitted by the court except in very extreme situations. And secondly, regulation as to time, place, and manner in which expression can be made, which again is a matter of balancing other requirements of public policy against the ability not to have a person prohibited absolutely from expressing their ideas or views, but rather limited in terms of when or where or under what conditions. The time, place, and manner, I'm sure you've heard, read, or at least perhaps even discussed the cases. The things such as the Nazi March in Skokie, Illinois, one of the extreme situations where the First Amendment protects the content of the expression, but that it is legitimate for the people responsible for maintaining safety and order in that town to determine where and when the marches will take place. We had a similar situation that occurred just a couple of months ago in Washington, D.C., when we had the Ku Klux Klan marching in the nation's capital, and we had counter-marches and counter-demonstrations. And in order to prevent the two demonstrations from flowing together in what might have been a rupture of the public order, there were time, place, and manner restrictions which were legitimate, but which did not infringe upon either party from expressing the views that they thought to be important. On the other hand, when it comes to content, the court is very careful to provide extreme protection to the expression of ideas. And it will generally strike down laws or governmental actions which are based primarily on content. And thus, in a case that was very commonly known to law students a couple of decades ago, perhaps less so today, but in Cohen against California, in which a demonstrator displayed on his shirt a word that was not then used in polite society. You remember that was before the Mike Tyson trial. And in that display on his shirt, he told the public what they could do with the draft. Well, this was the first case where the court said, Justice Harlan speaking, said that there are a lot of people who are going to be offended by this. There's no question about that. But he said the constitutional right of free expression is designed and intended to remove governmental restraints from the arena of public discussion, putting the decision as to what views shall be voiced largely into the hands of each of us, in the hope that use of such freedom will ultimately produce a more capable citizenry and more perfect polity, and in the belief that no other approach would comport with the premise of individual dignity and choice upon which our political system rests. Well, there might be some debate as to the dignity of the particular slogan that was on the shirt. Nevertheless, the importance of that means of expression was held by the court to justify the fact that while some people found it offensive, it could not be eliminated by the government. We've had some other interesting cases. For example, there was a move by radical feminists in the Midwest, in two different cities, to preclude what ordinarily had been, while some might find offensive, nevertheless protected speech in terms of magazines which exploited women or which were derogatory towards women. And it was very interesting because in that case you found strange bedfellows, if that's not an inapt expression, the very right of center people who were concerned about pornography and obscenity, and some very left of center people who were concerned about preserving the dignity of women, kind of banded together for to get passed by the city council an ordinance which clearly did not ban just obscenity, which was beyond the protection, but material which had traditionally been held to be protected by the First Amendment. And ultimately the court said that even in a case like that, the content of the material cannot be used as a basis for government banning material, even though it was offensive to a vast majority of the community, as long as it did not fall into that very extreme and limited category known as obscenity. And of course, perhaps the most significant event in regard to freedom of speech in the last 20 or 25 years has been the extension of the protections of the First Amendment, which by its language applies to free speech, also to certain actions which have been described by the court to be symbolic speech, or which they say are a part of the total ability to freely express views. The most famous of this, and I'm sure most of your recollection, is the case of Johnson against Texas, the flag burning case, where the court said even though it would appear to be abhorrent to most people, the use of burning a flag as a means of expression, or contrary to that, a statute, which makes the expression of views one of the elements of the crime. This violates the First Amendment and therefore cannot be upheld and countenanced by the court. Well, let's turn then, and I think that case, if there was any doubt in anybody's mind that the court is willing to go to considerable extremes in order to protect freedom of expression, the Johnson against Texas case ought to pretty well disabuse anyone of concerns as to the content-based test being limited or minimized by the court. Let's move then to the variety and complexity of cases. There have indeed been a number of very interesting cases that have been decided over the past couple of years. And again, they're testing the margins, if you will, of this whole issue of protection of freedom of speech. You had in Indiana, for example, the statute against nude dancing. And it was contended by those who were seeking to have that statute overthrown that this was a means of freedom of expression. And there's no question that there was freely expressed the particular talents of the people involved. But the court held in that case that the regulations did not have to do with content, but had to do with actions and conduct, which would be prohibited under any circumstances, and that therefore it was not a content-based ordinance, but rather was something that was being properly used in this particular case to apply to situations, as they said, whether people were on the beach or whether they were in front of the city hall or whether they were in a particular entertainment establishment, as was the case of the particular parties here, or for that matter, they said whether they were in the middle of a football stadium. A second case that has come up recently, and which tested again the limits of the whole business of protection of freedom of speech, had to do with the libel laws. Now, the libel laws have over the years been extended and extended in terms of what is permissible by writers, again so as not to infringe on freedom of the press, particularly as a means of expression. The particular case before the court, however, was a rather egregious example of misconduct by a writer who had taken statements which were paraphrased of what a person had said, and which conveyed in much more extreme terms and in distorted terms from the meaning of what the individual had said, and then put them in quotation marks in an article in the New Yorker. And they defended, the party there, the writer, defended that on the basis that this was within the poetic license, if you will, or artistic license of a writer, and that to call that and to hold that person responsible under the libel laws was to infringe upon that writer's creativity. The court held that because of the defamatory effect upon the plaintiff in the case and the damage done to that person by having something they didn't say put in quotation marks, which gave a very different meaning to what they had established to the reporter, that this was not an infringement on freedom of speech and that the libel laws properly applied. Another case somewhat similar has come up recently, and that was the case that maybe you saw. A person who was in a political campaign leaked some information to a reporter about an opponent. That material was used. It was done under a promise of confidentiality, because as the reporter knew, if it got out, if the individual knew if it got out that he was the source of the material, he would lose his job. Well, the newspaper reporter used this in a way to, in effect, castigate him for giving the material, and revealed his name in the story. And in fact, his prophecy was correct. He did lose his job. Now, the question is then, can that reporter then be sued in damages, or the newspaper actually be sued in damages under these circumstances on the basis that they had violated a contract to keep the name of the individual private, and then when they breached that contract or that agreement, then they were properly liable for, even though it was a matter of free press and free expression by printing the name of the individual, if that was in violation of a contract or an agreement, could they then be held liable for damages for the loss of the job? And the answer of the court was yes, that when an individual has an agreement and that is breached, we are not worried then on the principle of freedom of expression or press, but we are concerned with what was the agreement and what is the reasonable expectations of the individual. And finally, there was a freedom of expression case that involved religion, and that was the Peyote case, where people lost their jobs, applied for unemployment insurance. The unemployment insurance was denied. They claimed that that using peyote was a part of their religious expression, and the court held that the general laws that applied to the general population were not overcome when a particular religious practice happened to be in conflict with that law. Now, I mention all of these cases because it would appear to some that this was a retrenchment by the court on the strict observance of the First Amendment and the expensive protections that I talked about earlier. But actually, I would suggest to you that in each of these cases, it was a marginal case that was decided on very different grounds and decided on the basis of general law applying to each of these cases rather than what the court found in the other cases I mentioned earlier where protections were given, and that was a very heavy emphasis on content. These were decided on grounds other than content. Now, there is a most unusual situation about to occur in this country, and that is with the advance of technology, because we have the anomalous situation that with fiber optic cables and other things happening, more and more the telephone and telecommunications industry is going to be the primary locus of fights over free speech and over to what extent the government is able to regulate the transmission of information. And the interesting thing about it, from the standpoint of those of us who are watching First Amendment freedoms, is that the primary body or the primary industry that is seeking to limit freedom of expression and to have government regulation to a much greater extent than now exists over almost anything are the newspapers, who over the years have been pleading for freedom of the press for their own purposes, and who are now very much opposed to telephone companies and telecommunications industry being able to compete in the same area that they are. And so one of the most interesting things to watch, I think, over the next decade will be to what extent the principal body that has fought very well over the history of our country for freedom of the press and virtually no restrictions by the federal government or by any government on what they can print is now seeking to have very stringent restrictions applied to those who would do the same thing through the means of telecommunications. There is one other aspect of this that is coming up which will prove a real test for the Supreme Court, and that is a case currently before the court which is known as RAV against St. Paul. And basically what this case is all about is something that is coming into being more and more throughout the country, and that is hate speech statutes. Where doing an act for the purpose of exhibiting your hatred to others on the basis of race or religion or some other purpose, either is a separate crime, as in the St. Paul statute, or involves enhanced punishment, as in many other statutes around the country. And so you have this RAV against St. Paul case, in which there is a statute that says that it is a crime if you engage in essentially any form of expression on public or private property that a defendant knows or has reasonable grounds to know will arouse anger, alarm, or resentment in others on the basis of race, color, creed, religion, or gender. In this case, it was a burning cross that was burned on the lawn of a family in order to harass them by members of another race. The interesting thing was that it was obviously prosecuted in a way to test this hate speech statute, because there were ample other statutes under both state and local law to prosecute the individuals for trespass, for feloniously burning on another's property, and many other things. But the city wanted to test this hate speech statute, and this is up before the court at the present time. What's rather novel is that it has thrown asunder the usual parties on these matters, and you now have people who normally would be stalwart defenders of free speech who are on the side of the prosecutor, and you have many others who would normally be on the side of prosecution who are defending the free speech aspects of the case. For example, you have people like William Kunstler, who has been a stalwart defender of civil liberties during the course of his career, who is now opposing the Supreme Court upholding this statute, even though the civil liberties groups, including the NAACP and the Anti-Defamation League, and many others, such as the People for the American Way, are all on the side of the prosecutors. It's going to be a very interesting thing to see how the court handles this one. My own view is that hate speech statutes, while they may make people feel good, are really unnecessary in terms of the criminal law, inasmuch as there are adequate means to deal with the act itself, whether it be trespass, or whether it be burning, malicious burning, whether it be graffiti, defacing buildings, or whatever it might be, without having to predicate an element of the crime or an element of the punishment on the content of the thoughts or the intentions of the person involved. But I think it is interesting from the standpoint of the fact that it has turned up unusual people on opposite sides of the case. But let me talk about the third proposition that I made to you, and that is that the threat to free speech today comes less from what is happening in the court, legal, judicial circles, and that the greatest threat that we have is on the campuses of this country themselves. And that is what has been referred to many times as politically correct speech. The speech codes, which we find on many campuses and which, according to at least one survey by the Carnegie Foundation, are present in at least some form on close to 60% of the campuses in the country, I believe pose a much greater threat to civil liberties than those who would try to deal with matters even such as the hate speech crimes that we talked about a moment ago. This whole situation has led Nat Hentoff, a friend of mine with whom I often debate First Amendment issues, to write a column some time ago in Playboy magazine in which he talked about this whole situation and the chilling effect that political correctness and speech codes are having on campuses throughout the country. For example, he talked about a situation at New York University Law School where he said one student describes a host of watchdog committees and a generally hostile classroom reception regarding any student comment right of center. This may be one of the first times Nat Hentoff has defended those right of center, but in any event, the political correctness is one that has driven him to that position. And he says now, and he's again quoting another situation, he said, where words that create a hostile atmosphere or any language that involves an express or implied threat to an individual's academic efforts are now being singled out for criticism and censure and discipline. And he asked the question, why on earth are people on our campuses running away from language when they can turn a campus into a continuing forum on racism by using the vicious racist language directed at them to illuminate what's going on there, and to combat that with other language which would negate the effect of the racism? And he points out that rarely does the suppression of speech wipe out the underlying problem, but rather that where there is racism, or where there is gender animosity, or whatever else it might be on a particular campus, driving it underground by forbidding expression and debate doesn't solve the underlying problem, but only exacerbates it in the long run. And that the best way to combat bad speech, or speech with which we disagree, is more speech and extending the debate and presenting the other side. He uses an extreme example. He says, do women students want radical feminist Andrea Dworkin barred because of possible charges that she creates a hostile environment for male students? An interesting question when normally a lot of the sentiments would perhaps be with the position that she might take. And he winds up by quoting a former New York Times reporter who is now a law school student at a university in the West by saying, it is distressing that the politically correct view on campus these days seems to favor curtailment of speech. Oddly, defense of the First Amendment is now an anti-progressive view. Yes, speech is sometimes painful, sometimes it's abusive. That's one of the prices of a free society. But unfortunately, this is a lesson that has to be learned again and again. Well, I could go on with other examples. One that kind of strikes close to home, I suspect, the law students, is a situation at New York University Law School where they had a moot court case, and the moot court case happened to involve a divorce case in which custody of a minor child as a result of the divorce is awarded to a wife who is in a lesbian arrangement with someone else by a trial court which says that the mother's engaging in lesbian activities does not make her an unfit mother. Well, no quarrel up to that point. But the quarrel was that to require people to take the other side of that issue, to take the father's side, and to argue against that position of the trial court was, as some of them said there, hurtful to a group of people and therefore hurtful to us, and that the argument so consists of biased beliefs and attitudes, it's impossible to write a meaningful brief on this side of the issue. Now, I suspect that law students who feel that it's impossible to write a meaningful brief on any side of an issue still have a lot to learn before they go into the practice of law. Nevertheless, it brought forth an interesting comment from a person with whom I usually don't agree, Anthony Amsterdam, who in a letter to the Moot Court Board said, the declaration that any legal issue is not an open question in a law school is a declaration of war upon everything that a law school is. Most fundamentally, a law school is a place of intellectual inquiry where the acceptability of ideas can only be determined by examining them. Well, we could go on with other examples. Linda Chavez, who served in the same administration that I did, was invited to a speaking engagement at a Colorado university until they found out who she was, and then as soon as they found out she was a conservative, her invitation was abruptly canceled on the grounds that she would be a poor role model for Hispanic women and that inviting her was insensitive to minorities. In Delaware, you have the situation where the professors who were involved in exposing the race norming on employment examinations have been the subject not only of treatment of hostile treatment by their colleagues, but have actually been discriminated against in terms of promotions, tenure, and things such as that. The University of Connecticut had a speech code that banned what they called inappropriately directed laughter. And unfortunately, at some of the best colleges and universities in the country, whether it's Vassar, UCLA, University of Michigan, and so on, you have this proliferation of these speech codes which limit speech in the interest of somehow making a more calm, and peaceful climate on campus. I think it's interesting to note that the courts have stepped in on occasion, and certainly in the Michigan case, where it actually was taken to court, and the courts have said that it is indeed the case that speech codes, when they limit free speech based on the content of the speech, are subject. In this case, it was a state university, so in that case, it was subject to the First Amendment. But it seems to me the principle is there regardless of whether it's a state university or a state college, and whether it is a governmental entity that's involved. The principle of speech codes, political correctness, limitations on free speech, even for perhaps desirable motives, does establish a chilling effect on exactly the places where free inquiry, free speech, and free expression should be the utmost goal, and that is on campuses. And that's why I would suggest to you that citizens, whether they be students, faculty, or university officials, should not have to rely on a court enforcing the First Amendment, but that these faculty and students and officials, particularly those engaged in the study and education relating to law, should be the first people who would take action to prevent this sort of thing from permeating the campuses on which they exist. The former president of Harvard himself, Derek Bach, was very outspoken on this subject when he said, "At times, university administrators have unfortunately bowed to the threat of such pressure by withdrawing invitations to unpopular public speakers, imposing curbs on free speech in the interest of racial harmony, or forcing professors to include more material in their courses about women or third world issues." He said, and he went on to say, that the only feasible defense is to have university leaders who are strong enough to make it clear that academic standards and intellectual freedom will be preserved despite the battles that periodically erupt on their campuses. And let me just close, if I may, with the language of the professor, or the president rather, of my own alma mater, and that is Boehner Schmidt at Yale, who said, "I can only imagine what Madison or Holmes would have thought of this inversion of the theory of free expression. It is precisely societies such as campuses that are diverse, pluralistic, and contentious that most urgently need freedom of speech and freedom of religion." And he says finally, "This is not something we can leave to the courts. This is not something we can leave to the legislature. The political process is too prone to agitation about various sorts of speech to be a wise and stable source of enduring principle. If freedom of thought on campus is to be protected, the universities themselves must summon up the clarity of purpose to defend the principles of liberty on which the academic mission must rest." So I would suggest to you tonight, in summary, that I think that freedom of speech is alive and well in our country, that it is being protected by our courts, that the courts are making common sense decisions when you get these aberrational cases on the margins, but that on the campuses of our universities, we need to take the most care so that even well-minded but misguided people cannot use the academic atmosphere as a means of curtailing the most important ingredient of any true education, and that is free inquiry, free expression, and free speech. Thank you. Legitimate. The court held that this was not this was not a free speech issue, because that rather it was a matter of that when the federal government appropriates money, and the appropriations for the money say that none of this money shall be used for the promotion or encouragement or provision of abortions, that then it is proper to have regulations that clinics that are using these funds cannot counsel women to have abortions. Now, in this particular case, however, the decision became even less of an issue than it might otherwise, because this did not preclude doctors in those facilities from providing information to women about abortions or to counsel them on abortions as they would in any other situation. But the court basically held this was not a free speech case. It was a matter of, to put very colloquially, if you take money from the federal government, or for that matter any government entity, the strings that go with it can be binding. Yes, sir.
How do you explain your different positions there, position there with the position on hate speech, except by some belief that hate speech is less of a problem than a few ways where don't bear your threshold of belief?
Well, I think, actually I didn't take a position on it. I didn't take any published position on the issue. I watched it with considerable interest. My own view is I'm not sure that the court hasn't gone too far in extending speech and the protection of speech to acts generally. In other words, it seems to me that the court could well have cut off the protections of freedom of speech short of a person taking an action, whether it's burning a flag or burning a cross, and that would have been a very legitimate way in which the court could have preserved the expression of ideas and at the same time allowed government to regulate conduct. But the cases didn't go that way. The cases went in a way that even strong people for whom flag burning is abhorrent, such as Justice Scalia and Justice Kennedy, both of whom with whom discussed this matter, they felt that the case law on freedom of expression was such that this was protected symbolic speech. And so my view is that if that is the case, it's hard to distinguish that from hate speech. It would not bother me if the public determined as a matter of constitutional amendment that both the flag and having a community free from hate speech justified a constitutional amendment, although I don't think we ought to have constitutional amendments for every trivial item. But in principle, at least, that either one would be very offensive to me as preventing people from expressing ideas, since they could still shout on the corner at the top of their lungs the same viewpoints or put them on a sign and carry it around. I think that, in other words, I'm absolutely opposed to, as a person, to hateful speech or acts that are carried on in furtherance of that speech. But it seems to me that if once we have decided that actions are symbolic speech, then and the court has done that, then you can't let content be the guiding factor as to what kinds of speech are bad and what kinds are good. Yes.
How do you reconcile the role you play in why anti-war protesters virtually remain free speech with the United
Well, first of all, I didn't force any anti-war protesters. The only things that I was involved in at the time, and which I would say are not protected by the First Amendment today, are those acts which have nothing to do with speech, but which are clearly illegal. Sitting on the railroad track to stop trains, keeping people from entering draft boards or examining stations. In the case of it wasn't the war resisted thing, but the invasion of Sproul Hall, the campus headquarters there on the Berkeley campus, these are quite apart, and the actual commission of crimes, it seems to me, these things are quite far from what the Supreme Court has said is protected speech. So I don't think there's any distinction whatsoever. As a matter of fact, I am at least consistent in my view, which is different than most liberals, because if you take the liberal position that the war protesters who disobeyed laws, the civil disobedience of rights, then presumably they should be supporting the anti-abortion protesters in all these clinics. I think both are wrong. Yes.
You mentioned something you said before, I'm probably not necessarily what we call the political press movement, but I also think the captain are probably the focus. Maybe you said writing down anytime someone says something, you write it down, the person who is silent by the speech test. Rather, I think it's what the speech test directed at. It's a situation with some sort of harmony, some sort of fair play, and it's some big deal with it. And it seems to me that some of these speech tests maybe are written in a way that's incorrect. But there are some things that go on when you what we call a premise. If someone stands the other way and has that, I'm not sure that you say, there's a free speech that only goes in the presence of conversation.
Well, I would absolutely agree with you. And that, by that, I don't think you need the speech codes to do that. And again, when you base it on content, I think somebody who stands up in front of you and yells anything at you is probably committing a disturbance of the peace, or is there are other statutes that are applicable. I was not sympathetic to the fellow at Dartmouth, for example, who at 2 o'clock in the morning, is that you? Is that you? Oh, I see you had a D on your hat. I was a little worried there. But I was not sympathetic, and there it was quite clear to me that that person should have been disciplined if that's what they chose to do on the basis of being drunk and disorderly, which at least when I went to college was considered a heinous crime, except on certain days of the year. And but that should have been the basis rather than what that individual was saying. And I think the same is true. And I think one of the general exceptions which is included within the disturbing the peace is fighting words and that kind of thing, which is aimed to harass and really assault verbally an individual, which is something different than content-based comments, which can be applied in a much vaster context to people who are simply giving their views. I think that's where the problem is. Yes, right here, and then we'll get to back.
I'd like to return for just a moment to your response to that about the Morgan case. You had said there that it was not a speech issue, rather it was simply an issue when you receive government money, you may there are strings attached, I believe you said.
That's what the court said.
Now, in other situations, the court has held it's an unconstitutional demand to restrict people's First Amendment rights on central issues in return for receiving government dollars. It also seems to me that abortion is a central political issue and a fundamental political issue. Given that, I have a problem squaring the notion of stopping people from speaking about something as fundamental as abortion simply because of giving them government dollars.
But I think the court's view is that nothing precluded the individuals who are receiving federal money from going out and arguing, talking about abortion, saying that they're in favor of abortion and expressing their views freely, but that this was a form of treatment for which the federal government was providing the money, and therefore they had the ability to limit the manner in which that treatment was provided, making a distinction between First Amendment rights on the one hand and what the purpose of the funding was on the other.
Alternatively, couldn't that be simply limiting people in the form that is the most forceful?
Well, it could, but the court didn't find it that way. Yeah.
A recent article in the New York Times described the U.S. government actually behind a patent to a company called Old Glory Commerce Company because the trademark was offensive and scandalous. The word was actually in the trademark statute because the office denied an offensive or scandalous trademark. How does this theory square with the definition of the government?
I don't know all the facts of the case, but I would say that again it would be a question of to what extent a patent is a right granted by the government, within which, somewhat akin to what we've been discussing here, in which the government can attach certain limitations and strings to a much greater extent than they would under other circumstances in which free speech is more directly involved. Well, I suspect they could. I don't think you need a trademark in order to manufacture condoms. But I suspect what they wanted to do is patent it, or perhaps they have a new design. I don't know. But in any event, I think what they were trying to do was to get for themselves the exclusive right to use the flag on the condom. From what you've said, I don't know all the facts from what you've said, and the patent office says we're not going to be a part of that. That's a little bit different.
Wasn't for the patent, wasn't for the trademark. They had a
Yeah.
trademark flag on the front of them. That was deemed to be dangerous and offensive. As it was very much similar to Texas Johnson.
Well, except that the difference is that in Texas against Johnson, Mr. Johnson was not applying to the government for certain protections for him in the process of burning the flag. And so I think that would be a distinction I can see without knowing more either about the trademark law or the particular case. Yes.
John Lewis, who is a columnist for the U.S. Newspaper, recently wrote an article about political correctness across college campuses. And he quoted a quotation from a senior law professor, I forget her name, who said that the way that the current court has interpreted the First Amendment is certainly because it is favored patriarchy over matriarchy. I'm trying to make sense of what she said. I certainly can't say anything to help me.
I'm afraid I haven't read that, and so without knowing the context or what she said, it's hard to comment on it. And I don't know how the court has somehow upheld patriarchy over matriarchy without knowing more about it. I didn't see the column, unfortunately. I usually read John Leo's stuff, but I didn't see that one. I'm sorry, I can't help. Yes?
In West versus Sullivan, it's fair to say that what you're saying is that he was just takes 16 shillings to make a state of the art. He was taking 16 shillings to 16 songs. It's a comparable case, I think, that fellow which began to sue the National Endowment for the Arts, saying that the Helms Amendment was a restriction upon freedom of speech, and they won that case, and proving, in effect, as they said, in the United States, you can take 16 shillings, and you do not have to 16 songs. Do you see the two cases being in any way comparable? You can buy second-hand receipts.
Absolutely, and I don't know the exact holding in the Bell-Lewitsky case. I don't think it was a Supreme Court case. It was a lower court case, and I think that there may be a distinction there in the sense that on the one hand you have freedom of expression, on the other hand you have what is deemed to be paying for a mode of treatment, and so I think that there may be a difference between the National Endowment for the Arts and a medical procedure that's being funded by HHS.
But the Lewitsky was received federal funding.
Yeah. Right. I think there are cases. I think there are cases where it doesn't apply as closely as it does in this case, where the whole subject of the grant is people for freedom of expression. I've got a lot of problems with the National Endowment of the Arts, and one of the problems is that I think we put the government in a position of determining what's good art and what's bad art. And that's why I don't think they should be in that business at all, quite frankly. Oh, yeah, but the citizen panel just the other day turned down a couple of grants on the grounds that they were pornographic. And John Cromeyer is defending that on the basis that we have the job to decide what's good art and what's bad art. I think that having been in government's no place to decide what's good or bad art, I can tell you that. And that's my solution to that is to do away with the National Endowment for the Arts and give everybody who wants to be a donor to the arts a double tax deduction for their donation, and let people make their own decisions as to what's good art and bad art, and get the government out of the business. I think it's much sounder way of going, both from the First Amendment and from the standpoint of the artist. I think you'd do a lot better under those circumstances. Yes?
You mentioned that employment duties
Yeah.
I would generally agree with your characterization of the work that you can do, common sensible, and when you go to hate speech, it's really not necessary to have that kind of ordinance to prevent cross-burning. But when they went and looked at Indian practice, and the practice has been thanks to thousands of years of practice without causing any mental harm in the society, I mean, they were kind of quick to go from the common sense perspective to draw a little bright line that isn't that level of abstraction. I have to hear what that's going to do, in the future when you do whatever the balancing test and go towards a right line rule where a lot of things are neutral, and you run all of that, you have to think about the benefits. What do you think of that?
Well, it was one of those cases where the question was, is the Constitution and its protection of freedom of religion so strong that it overcomes, in a sense, the presumption that the people can do what they want in issues of health and safety through their legislature? And that's really what the issue was. In other words, does the Constitution require us to say, you, the people, by a democratically elected majority, can't do that? Do something for the protection of the public, a health and safety issue. And that's where you have these two things. There has been a lot of mythology that there was this compelling state interest test that had been applied to religion cases up till that point. Well, it had only been applied in 1.5 or at the most 2 cases. So there was not some big compelling test that had been a long derived principle of construction of the First Amendment. So I think the court was, personally, I kind of like the compelling state interest case in religion cases as a matter of personal choice, but I think the Constitution as it presently is enacted doesn't require it. And actually there is a Religious Freedom Restoration Act where they will try to do this by statute to provide the same protection, and I have no quarrel with that. There's somebody over here, yes sir, and then we'll get you.
Okay, your opening comments, you thought that students that were given at the graduate examining and I think maybe in some areas, but the key very important areas I think is curriculum and especially the last half century. And one of the things you brought up was the audience and the national on making sure that what government thinks can tell we can bring our bodies and money to our life. That's certainly really important. When the Constitution was accepted, I think both George Washington and Congress and the called heroin people like behavior used a lot. But I think the more important point is that the First Amendment is looked at in importance because it wants the citizens to have informed political views on what government can do. I think in the recent history, you see a gradual growth of our rights and the of what our government is doing. I think that's very important explanation that I'm open to what the Vietnam War was also. And certainly the coverage of the Gulf War was much less than the Vietnam War. And during the Vietnam War, we were seeing the threat of communism and how that sort of gone. How can you reconcile that with the notion that?
Well, you've hit on first of all, the first area you talked about, narcotics. My comments were as to the First Amendment, and with the exception of the possible coyote case, that wouldn't be covered by the First Amendment, therefore not covered by my comments. On the second aspect of your question, national security is a legitimate area. On the other hand, I think it is a matter of balancing. In the case of the Persian Gulf War, the reason we had a lot less coverage was, of course, because it ended so quickly. I suspect if you had the coverage, well, actually the coverage in many ways was a lot better and a lot more extensive than the Vietnam War, because you at least had the people seeing the same briefings that the news people had. Now, whether you think the briefings went far enough or that sort of thing. Yeah. Yeah. And I think that was a question in terms of national security. To what extent do national security requirements preclude the press being kept out of zones? And there are a lot of reasons why I concede that they would. For example, in this particular operation, a lot of strategy had to do, and remember, I think that if this had gone on for 7 years like the Vietnam War, you would have seen them right up there all the time. But it didn't, and in the early days of the fighting, a good deal of the strategy had to do with certain units making dummy landings and feints and a lot of other strategy where if the press had been allowed to be there, they would have gotten that information and probably would have used it. Because the one thing that I don't think you can depend on is sometimes the good sense of the press in what they're going to do. But I think that was the main thing there. Yeah. Well, absolutely. It should be released now, and it shouldn't have been withheld then, in my opinion. Yes.
Next point is the one case, the bond case, the national contract, and
Well, I think they went to great lengths to point out that it was not content that was the motivating factor. For example, in the nude dancing case, they said if this had been limited to nude dancing at a political rally, I mean, they didn't say it, but this was the implication, at a political rally or some other thing that was directed at what they were advertising or proclaiming by the conduct, that would be one thing. But that where it applied to any kind of a situation, including recreational, including sports or whatever, that this was not content-based. And it seems to me that that's not an unreasonable conclusion on their part. It certainly didn't stop any one of those people who were performing from expressing their views either verbally or with signs or anything else that would not be offending the particular statute that was involved. And I think unless you feel that that's the only way those particular people could get attention to their views, then it seems to me that the court was right in upholding this as not a content-based type of thing.
Let's say that there was something on the court they wanted to get into the dancing. You've got to admit that if they want to do that, it's far easier to do it if you're going to talk about it as non-content.
So remember, it's not the court that wants to get at nude dancing. It is a body of democratically elected legislators who want to say that that's forbidden. And the question is, does the court now have the power in the Constitution to overrule that democratically arrived at decision? And that's why the court often is constrained as to how they apply the Constitution so that they're not overreaching their own boundaries to undo something that the people, as expressed by their elected leaders, are enacting. And that's one of the great difficulties that Justice Scalia has said many times. You may not agree with the result, you may not think it's just, but it is the law, and that the court is as limited by the Constitution in what they can do in overturning democratically arrived decisions as the legislature is limited by what they can do. Any other questions? Yes?
I'd like to maybe more of a religious establishment case that I don't think you're familiar with the license case and what I
Yeah.
I'm not that familiar with this particular case other than a rabbi being an education at Union High School and a young woman objecting to it. How do you feel about that case?
I'm not sure how it's going to come out. I don't think the current state of the Supreme Court law on establishment of religion is justified by the history of that doctrine down through the years. Because up until the last 40 years, roughly, I think the first case was in 1947, up until that time, non-sectarian prayer at public occasions, including educational occasions, and non-sectarian references to religion, as long as they didn't prefer one religion over another, were generally accepted. And it's been only recently that this idea of a wall between church and state has grown up, which was a two-way wall. My own review of the history is that that's probably a fallacious doctrine, and the Chief Justice Rehnquist, in his dissent in some of the recent cases, probably has it right as far as the history. So if in the Wiseman case they came out with the idea that a non-sectarian prayer at a school event, such as a graduation, was not prohibited by the Constitution, whether it's good sense or not is really not then up to the Supreme Court, that's up to the school district. It would not bother me. However, I would be surprised if that happened. Yes.
What do you characterize the situation as? That a lot of the hate speech goes on the personal and so far as I think we use that be it and fighting words.
I think in most cases they could, yeah. And not only that they're unnecessary, but that they're unnecessary to protect what should be protected, and they're pernicious in the way that they're being utilized to stifle free speech. Any other questions? If not, let me just thank you for being an excellent audience and for the privilege of being here at Harvard. Thank you very much.